All right, good morning, everyone. I'm Judge Jackie Powell. This is First Appearance Court. Today, I'll let you know if I've determined probable cause from the police reports I read this morning. Then we will talk about release conditions. Today is not your trial date. It's not an adversarial hearing, and so because of that, every morning I encourage persons to speak with your attorney before speaking on the record. Everything in this courtroom is being recorded and can be used against you at a later time. For those of you who are represented by the Public Defender's Office, in the courtroom with me this morning from the Public Defender's Office is Mr. Faberic, and over at the main jail, there is Mr. Romero. These attorneys are available to those of you who are at the other facilities by phone. So everyone has an opportunity to speak with an attorney before saying anything on the record. Those of you who are represented by private counsel, your attorney will come to the courtroom. If your attorney's not here, you can let me know, and I will see if I can reach your attorney if you have the name or the information. However, please don't tell me that you have private counsel unless you or your family have actually retained that attorney for this arrest. Just because an attorney has represented you in the past or maybe representing you on a pending matter does not automatically mean that they're representing you on another case. And so oftentimes persons tell me this and then I make the phone calls and the attorneys say, no, I'm not representing them on this case. And so I need you to understand that unless you've retained them for this arrest, they're not representing you. Also in the courtroom with me, I have the attorney from the state attorney's office, Mr. Eric Linder, and we have representatives from confinement status, pretrial supervision, the clerk of courts, and all these persons are here to help with this morning's hearings. In some circumstances, they can provide additional information, so you just need to be aware of that. After today, your cases will be assigned to a specific division judge, and then moving forward, any pretrial motions, or if you have trial, will be decided by that particular division judge. Some of you, those of you charged with misdemeanors or municipal ordinance matters, you may be able to resolve your case at first appearance, but that's going to be dependent on what's going on with you personally, all right? Those of you facing felony matters or where there is a warrant for a violation of probation and there's a no bond hold that your judge has already issued a capias, those cannot be changed at first appearance. So you just need to be aware of that. All right, for Mr. Fabric, has the jail asked for anyone to be called out of turn? All right, so then, just so we know, there's some of you who've signed in. I just have to check and make sure that they're in the room because they don't bring everyone in all at the same time. So, Mr. Romero, if you can help me on, good morning.
Everyone's in the room, but I'm only up to page 15.
All right, so on page 15, Matthew Bro is represented by private counsel.
Mr. Bogan.
Is there?
And I see him.
Okay, all right.
Come on up. Mr. Bogan is there, okay?
Oh, this is,
Yeah, exactly, Your Honor. And
do you have it?
no, Your Honor, I spoke with Detective Mentzler
Yes.
this morning. He's on his way into the office. Once he will get there, he said it should be about 9 o'clock. He will be emailing me a copy of the affidavit.
All right, so this is Mr. Brogan, just so you know, I have the warrant to arrest, but I didn't have the probable cause affidavit.
I spoke to counsel before the proceeding started today, and I'm prepared to wait until it gets here.
Okay, all right, so then
If you
we'll.
could pass this, please.
Sure.
Thank you, Your Honor.
All right. All right, so on page 10, Leonard Diaz.
Mr. Diaz, he is here. Yes, he is here, Judge. Come on up, Mr. Diaz.
Okay. And so just for information, the next person who signed in for someone who's on page 16, you're indicating.
Yes, sir.
We're gonna have to wait a little bit. I don't know who that was, because the attorney says he's only up to page 15 with speaking with the persons. All right, so Leonard Diaz, who's on page 10, Mr. Diaz is charged with driving with a suspended or revoked license. Number 2 is an expired vehicle registration over 6 months. And then number 3 is a KPS, it's a misdemeanor KPS that was issued on October 21 of this year on a case where Mr. Diaz did not show up for arraignment, and there the charge is failure to register vehicle, right? So he has a CAPIS that was issued by a division judge for not appearing in court. There's a $250 bond that's attached to that. As of now, it is showing that he has a status hearing with that judge tomorrow at 9 a.m. I find probable cause. Good morning, ma'am.
Aunt,
Yes?
sister of his mother. I'm here to represent her because she lives in another state.
Okay.
Just to let you know, he's a very good young man. Unfortunately, it's so much stuff on his head, and he tried to put everything together since he came back to Florida. He's a good Christian man. He never been in trouble with any kind of problem, and in fact, he's going to the military. He's already, in order to serve the country, and that's his counting to do too. I'm trying to do my best to love him so much.
Well, ma'am, these types of charges sometimes are as a result of, his license is revoked, and I don't know why that is, but that's something that you have to take care of.
I will help
And-
him, but he said, I'm sorry to interrupt you. He said
Well,
to me,
no, stop talking for a moment. And then there is a capias that is issued. He was supposed to go to court on October 21. He did not show up for court. These things have nothing to do with, whether you've been in trouble or you stay out of trouble. These things are when you have to show up, when you have an appointment with the court, you can't just blow it off. You have to go. And when you have issues, if you don't deal with them, then this is what happens. And this is what this situation is about. Somebody not taking care of whatever is pending and then picking up another charge for driving with a suspended license, all right? All right, State,
Yes, Your Honor.
Mr. Romero, is there anything that you wanted to say?
Judge, Mr. Diaz is not, interested in resolving. My understanding, he has a, basically clean record. He advised me he never received notice, for this. He just advised me he did move, so I was trying to inquire whether or not he updated his new address with the clerks. That's the information I have at this time, Judge. Can you actually tell him that I'm in the system also in the United States?
All right, well, I don't, he has a total of $275 in bond. And as I said, otherwise he has court with his division judge tomorrow. Okay?
Your Honor, if I may, just for his own edification, Hector, you might want to advise him if he's considering going to the military, you might want to go to Virginia and take care of that trespass case where there's a warrant issued for him.
All right? Okay, folks.
Thank you.
All right. Last name is Polly.
Your Honor, if we could put this on recall, the information I received this morning from the victim advocate, she spoke to the victim and he was going to be coming to court to,
All right, so I'll recall
that.
that. Natalie Vincent. Yes,
She's
please.
approaching, Judge. She's here at me. Come on up, Ms. Vincent.
next case.
Ms. Vincent is before the court on one charge of aggravated battery causing bodily harm, and number 2 is violation of an injunction, and I find probable cause.
Your Honor, the state would be seeking a $10,000 bond on count 1, a $5,000 bond on count 2, no victim contact, a GPS monitor, and based on the allegation that she violated a court order by returning to the victim's residence, which she admitted to. Ms. Vincent was arrested for battery against a different alleged victim last year. The case was dropped January of this year. She had just a couple other priors, but they're not related to this, and they are dated.
Judge, unfortunately, what the state is suggesting, a $15,000 bond, that's something financially impossible for Ms. Vincent. Now, she's been living here for over half of her life. She's 40 years old. At this time, she's not working. She's basically a stay-at-home mother taking care of her children. She's been residing in the same apartment for 1 year. She has 4 children, Judge. My understanding is I did advise her because it's a domestic situation. The court's going to impose a no contact order. She will be abiding by that court order. But unfortunately, like I said, we don't have a problem as far as her being supervised by pretrial standard. But I was going to be asking the court for a lower monetary bond, $2,000 on count one, $1,500 bond on count two. We're going to be requesting a total of $3,500 on Ms. Vincent's behalf, Judge.
All right. At this time, I'm going to impose a $5,000 bond on charge one and a $5,000 bond on two. No victim contact. There is an injunction in place that says you are to have no contact. It means no contact. A judge issued that order. So no victim contact means no phone calls, no text messages, no social media, no third-party contact. No contact means you do everything in your power to stay away, 500 feet, stay away. Don't go anywhere near the person because there's an order in place that says no victim contact.
And Your Honor, just so there's, as far as the injunction, so there's no confusion, because I know Ms. Vincent, in the report, she claims that she thought it was over. So the court's aware the injunction was permanent, and if you could advise.
So for until eternity, no victim contact. Jordan Lowe.
No problem, Your Honor. Good morning. No problem.
Good morning.
All right, good morning, Ms. Lowe. Ms. Lowe, you're before the court because there's a capias that was issued. That capias was issued on July 2nd of this year. That charge on that case was possession of cannabis, 20 grams or less. Yes. All right, so I find probable cause. I have been advised by confinement status that your bond has been posted.
Am I able to resolve it today?
No, but your bond has been posted, so,
Okay. Thank you.
okay. All right, Mr. Shade? All right, on page 9, Marlon Wilkes.
No problem.
Broward? All right, Mr. Wilkes is before the court on a capias that was issued November 21st of this year. The charge there is possession of drug paraphernalia.
The city of Fort Lauderdale would offer time, sir.
All right, so, Mr. Wilkes, if you wish to resolve your case today, your attorney is indicating that the city has offered adjudication and time served to resolve your case. Do you wish to do that?
Yes, ma'am.
All right, sir, I need to ask you a few questions to take a plea. So first, will you raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. Please state your name for the record.
Marlon Wilkes.
And Mr. Wilkes, do you understand everything that we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Wilkes? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication time served. Good luck.
Thank you.
Page 9, Stephen Morris.
Yep.
Please approach.
right, good morning, Mr. Morris.
Good morning, ma'am.
You are before the court today because you have 3 municipal ordinance violations.
What?
And I find probable cause for these charges. And,
Judge, they prefer, this is the 10th or 11th arrest they said for the city of Fort
Yeah.
Lauderdale for this year. They prefer to go to the division.
and just based on the allegations, Mr. Morris, I am not going to accept any pleas this morning. So, I'll leave the bond in place at $25. You have an attorney who's here and, he'll speak with you further about these charges, okay?
Louis Sentinel?
All right, Michael Tapia.
Same thing, Judge. Sent to the division. And Kathy is also going to be sent to the division.
All right, Mr. Tapia, you are also before the court this morning on 3 municipal ordinance violations for which I find probable cause. They're open container, panhandling, and trespassing. Those are the charges. So, and also based on the nature of the information provided in probable cause affidavit, I'm not going to accept a plea today. You have a $25 bond. Your attorney's here. You need to speak with him further in regards to resolving your case. On page 10, Antonio Hawkins.
Mr. Hawkins?
All right, Mr. Hawkins, you are before the court on a misdemeanor capious matter.
It's a time
You,
served officer.
you didn't show up for your arraignment on December 5. The charge is possession of drug paraphernalia. The city is offering you time served to resolve your case. Do you wish to accept that?
I accept.
All right, Mr. Hawkins, then I need to ask you a few questions, so I'm gonna ask you to raise your right hand. Do you swear or affirm to tell the truth?
I do.
Okay, you can put your hand down. And do you understand the offer that has been extended to you today to resolve your case?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
I do.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Hawkins?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication, time served. Good luck.
Thank you.
Thank you, Mr. Shade. The Spanish interpreter is here. Who needed the Spanish interpreter?
Judge, there's 2 people on here at Maine that require the assistance of the Spanish interpreter. The first person is on page 13 of the court's docket. His name is Mr. Mazariegos Perez. Mr. Mazariegos Perez. And the second individual is on page 18 of the court's docket. His name is Mr. Edson Vasquez. It's Eric Mazariegos Perez.
I got it, thank you. Madam Interpreter, if you'll raise your right hand. Do you swear or affirm to interpret from Spanish to English, and English to Spanish?
I do. Maria Salazar, certified court interpreter.
Thank you, Ms. Salazar.
You're welcome, ma'am.
Eric Mazariegos Perez,
Señor Eric Mazariego Pérez,
you're before the court this morning for an immigration hold.
¿está usted acá esta mañana por una retención de inmigración?
It is a no bond hold
Es una retención que no lleva fianza.
by the Department of Homeland Security,
Ha sido emitida por el Departamento de Homeland Security.
and you will have to appear before an immigration judge on this charge.
Y por este cargo va a tener usted que comparecer ante un juez de inmigración.
I find probable cause.
Y sí encuentro causa probable.
Edson Vasquez,
Señor Edson.
He's approaching, Judge.
all right, Mr. Vasquez,
Señor Edson Vázquez,
you are before the court for an immigration hold.
usted está acá ante esta corte por una retención de inmigración.
It is a no bond hold by the Department of Homeland Security.
Es una retención de parte del Departamento de Homeland Security y no lleva fianza.
I find probable cause,
Encuentro causa probable
and you will have to appear before an immigration judge on this charge.
y por este cargo va a tener usted que comparecer ante un juez de inmigración.
All right. Is there anyone else who needs a Spanish interpreter?
Not at me, Judge.
All right.
All right, Mr. Romero, on page 16, thank you, Ms. Salazar. On page 16, do you have Terrence Smith? Are you ready with him? Page 16, Terrence
Yes,
Smith?
Judge.
Okay. All right, Mr. Smith is before the court this morning. Charge 1 is resisting officer without violence. Number 2 is a felony violation of probation, and that has a no bond hold. Number 3 is driving while license suspended. Number 4 is operating a motorcycle without license. Number 5 is failure to register motor vehicle. So I find probable cause for these charges, and as I said earlier, the no bond hold that has been placed by his division judge is not something that can be changed here at first appearance. He does have a court date tomorrow at 8:30 a.m. on that violation of probation matter. I find probable cause, and aside from the no bond hold, he has a $100 bond on charge number 3, okay? All right, Ebony Silvas Price.
She's approaching, Judge. You have me.
All right, Ms. Silvas Price is before the court on one charge of touch or strike battery. Charge number 2 is resisting without violence, resisting officer without violence. I find probable cause.
Judge, at this time, nothing to add.
Your Honor,
Yes.
state's going to be requesting a $3,500 bond on count 1. Ms. Silva's Price is currently on probation before Judge Solomon for battery. I would note the allegations in that case is that Ms. Silva's Price and 3 other women confronted the victim, and Ms. Silva's Price attacked her. It's worth noting in this case, Ms. Silva's Price and another individual, who I believe is the next person on the docket, are accused of attacking the victim.
So you're saying that the nature of the charge is similar, it's not the same victim?
It's not the same victim. It is similar in nature in that it's Ms. Silva's Price. She's not confronting when these batteries occur. It's not just her and one other individual. She's outnumbering individuals.
Any other priors aside from what's pending?
As an adult, I just saw the battery.
Okay. And how much bond did she post on the other case?
1 moment, Judge. Originally, there wasn't a bond. It was an issue summons. Then a capias was issued, and she posted a $500 bond.
Okay.
Judge, she did give me the phone number of her grandmother. That's who I was going to call to help post a bond. She thought that her grandmother, using the services of bonds, and can afford to pay the premium. Now, Ms. Silvas is working. She works at Home Depot, making only $11 an hour. That's why she'll be able to do the $1,000 bond, but anything more, I do not believe that Ms. Silvas will be able to afford.
How recent is the other case?
It's a 2018 case. She was placed on 6 months probation July 31st of this year. There's also supposed to be anger management classes.
Oh, it's a violation of, well, she's on probation is what.
Till
well,
January 31st of next year.
All right, so I am going to leave that $1,000 bond in place. No victim contact. If Ms. Price posts her bond, this time you're gonna be on a level 2 pretrial supervision. No victim contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that?
Yes, ma'am.
Okay. Ayana McKeithen,
She's approaching, Judge.
all right, Ms. McKeithen is also before the court on one charge of touch or strike battery. Number 2 is resisting officer without violence. I find probable cause.
Judge, I'm gonna be requesting a photo order on Ms. Keithen's behalf.
Okay? Any priors on Ms. McKeithen?
I don't see anything as an adult. I don't have her juvenile history in front of me.
All right, so $1,000 bond, no victim contact. Ms. McKeithen, that means no phone calls, no text messages, no social media, no third-party contact. Do you understand that?
Yes, ma'am.
Okay. All right, Chenoa Acevedo,
No problem, Judge. Yeah.
all right, Ms. Acevedo, you're before the court on a traffic capias.
Yes.
You did not show for your arraignment on December 9th. The charge is operating with a suspended driver's license, a second offense. That judge issued this capias with a $500 bond. I
Judge,
find
just-
probable cause.
I'm sorry, also, just so the court knows that she's hired Kevin Kulik. She indicated that he was retained. I did call the office this morning. Nobody was able to answer, so I left a message that she was in magistrate court this morning.
Okay. All right, so
I was sick that day.
did you hear that, ma'am?
Yes.
All right.
I was,
Well, you have court tomorrow before your division judge, and you have a $500 bond. I am going to leave that in place, okay?
could I be released today?
No, ma'am. All right, Tiffany Sowers.
This is a medical research, Judge.
Sowers is a medical reset.
Your Honor, I would just ask if the court can make a PC determination, because that way, even if she doesn't post bond, the clerk can assign a judge.
Tiffany
Central.
Sowers, oh, it's a capias.
Exactly, then she can,
All right, so, and the judge issued a $1,500 bond, so on Ms. Sowers, I find probable cause. All right, DeSalis Vicarini,
Yes, Your Honor.
all right.
I'm
Ma-
here with no disrespect to the court.
All right,
I've
yeah,
al-
okay, ma'am, don't start talking, all right? I go first, and then I'll give you an opportunity to speak if you wish to.
Thank you.
And also, you need to know before we get there is that everything in this courtroom is being recorded and can be used against you at a later time. So my encouragement to everyone who comes before me, if you have an attorney, speak with your attorney first before saying anything on the record, okay? You are before the court today for one charge of touch or strike battery, and I find probable cause for that charge. Okay, so I will hear from anyone who wishes to be heard at this time.
Judge, I did speak to her earlier this morning on the phone. She indicated that she's been a resident here for 14 years. She is widowed. She does have a little bit of money, but not a lot. The issue is really she has no access to it. She recently broke up with her boyfriend. He took the credit card. She had to reorder credit cards, bank cards, stuff of that nature, and they are coming within the next 5 to 7 days. But she doesn't have them in her possession, so she can't access her money. What I would be asking, and what she's asked me to ask the court for, is if the court would ROR her on these charges, because she's basically stuck. She does also work. She works at Outback as a waitress. So, in light of the fact that while she has money available, she can't get to that money, and there would be no way for her to get out, we would ask the court to consider RORing her.
Under the concern I have, this will be, it's just Broward County alone. This will be Ms. Vicarini's fourth arrest for violence since 2018. She was arrested for domestic violence battery just, this year. That was Noel Prost, November 19th. She was then arrested for domestic violence battery 2018. That was dropped. 2018 felony battery due to priors in violation of an injunction. Those charges were dropped. Not the same victim as in this case, but it's just a repeat in allegations of violence.
Okay. All right. Ma'am, I know that you started to speak. Do you still wish to say something?
Yes, I do. I have showed up for every court case, even court calls. The last one I was let out on my own recognizance, and I even showed up for court calls. I will be there. I just have no way, like he said, to access my money. They're going to a 2020 Scott address because I was put out by my husband, which is a homeless shelter. I have to show ID in order which to pick them up. They're my pay cards that I get paid through my credit cards. And there is money already on there.
Your Honor,
You were put out from the homeless shelter? I don't understand.
No, I was put out from my husband on Friday before the 13th. The officer took me to 2020 Scott Street, which is BSO. That's where I ordered my cards, and that's where they'll be delivered because that's the only address I have.
All right, yes, State.
I can advise you, the last case she had, she was placed on a GPS monitor. There was a violation for failing to, I guess she was unable to charge the GPS monitor. A revocation warrant was signed. Judge McHugh did end up RORing her back to pretrial.
And I did show up for everything like I promised.
Nothing further, Judge.
Well, I'll let everyone know that I am not going to ROR Ms. Vicarini, just to ROR her. And if she doesn't have a place for me to put her on a level 2 pretrial, then I'm gonna leave the bond in place. All right, so just $1,000 bond. I'll leave that in place at this time. All right, Burviley Lauriston.
I'm done, right?
Judge, she also indicated, they're at Main Jail, but I was told that she indicated she has a private attorney. I know they've been trying to call over there to speak to her brother. They've been unable to reach whoever the attorney is. She doesn't know who the attorney is, but they have retained
Judge,
private counsel.
We just found out, we spoke to her brother, and unfortunately, her brother has not hired a private counsel yet, so she's changed her mind, and she's right now applying for public defender, so if we could put her on brief recall so I can speak to her.
Okay,
Never mind.
Thank you.
all right. Luna Hernandez.
Paul Ryan.
All right.
Ms. Hernandez is not going to be able to attend. She's going to have to be a medical reset.
All right, thank you.
Your Honor, I just asked if the court would be inclined to make a PC determination.
This is not the first time?
No, she was a medical reset yesterday also.
All right, so, Ms. Hernandez, is facing possession of cocaine, possession of alprazolam, possession of cannabis, 20 grams or less, possession of fentanyl. I find probable cause for these charges, okay? Thank you, Deputy. Justin Berry? All right, Mr. Berry is before the court on an out-of-state felony hold. It looks like you have to go back to Kentucky to deal with these issues. I find probable cause, and you will have to also go before the extradition judge on this matter, okay?
Is there a date for the extradition, Judge?
Well, extradition court is held every Tuesday and Thursday of the week, so maybe you'll get in before the Judge Malik on Thursday, okay?
Thank you, Your Honor.
All right, Thomas Corness.
approaching judge.
Mr. Corness is before the court on one charge of aggravated assault with a deadly weapon. Number 2 is domestic battery by strangulation, dating relationship. Number 3, battery causing bodily harm, domestic violence. And I find probable cause. All right. Does Mr. Corness have any priors?
He does, Your Honor. One moment. 2017, he was arrested for resisting without violence. He pled that out. He was also arrested for battery. That was domestic in nature. It was dropped. What I think the court should be aware of, and it is a cause for concern, in the report, the arresting officer mentions that the dispatcher advised of an officer safety situation at the address. The safety flag was due to a previous incident in which the occupant of the home, Mr. Corness, was firing a gun inside the house during a dispute. That is concerning for obvious reasons based on the allegations in this case, Your Honor. Additionally, he has a felony criminal mischief 2016, a DUI 2015 with an enhanced breath. He violated probation in that case. Based on the allegations, Your Honor, and I would also note Mr. Corness's admissions to the charges, the state would be seeking a $15,000 bond on 1, $10,000 bond on 2, a $5,000 bond on 3, no victim contact, pretrial release of the GPS monitor. Hello? Yeah.
All right, Mr. Romero?
Judge, unfortunately, Mr. Corness is not going to be able to afford that monetary amount. He was previously working at a warehouse. He's no longer working there, and he's looking for employment. Now, he's 22 years old. He's been living in our community for about his whole life, except for 2 years, I believe. He lived somewhere else. Right now, he's looking for employment. Things haven't gone well as far as that front goes, so what he's doing is he's enrolling in Atlantic Tech to try and pursue some sort of welding career. Hopefully that would open up more doors. Now, I did advise him that, of course, going to impose a no-contact order. He will abide by that. He'll live separate and apart from the alleged victim. He has his father, who resides here locally in Broward County. That's who he's going to go and reside with during the pendency of this case. But unfortunately, from what he advised me, he does not think that his family is going to be able to come up with that much. So I'm going to be requesting that the court consider a $5,000 bond on count 1, a $3,000 bond on count 2, $1,500 bond on count 3. So if my math is correct, we're requesting a total of $9,500. And because of the circumstances of the case, Judge, we wouldn't oppose also having Mr. Corness supervise on standard pretrial release.
All right, well, based on what I've reviewed here this morning, and what I've heard in previous history, I find that a reasonable bond on this case, charge number 1, the aggravated assault, I am going to impose a $10,000 bond. Number 2, $10,000 bond, and number 3, $5,000 bond. If Mr. Corness posts his bond, he'll be on a level 2 GPS, no victim contact. No victim contact, sir, means no phone calls, no text messages, no social media, no third-party contact. No weapons or firearms, if you have any weapons, those must be surrendered before your release. Rashad Raming.
Mr. Rahman, come on up. He's approaching Judge here at Maine.
Mr. Raming is before the court on a domestic battery by strangulation charge. I find probable cause. I'll hear from the parties in regards to bonds.
Based on the, I don't see history. Based on the allegations, Your Honor, I'm going to be requesting a $7,500 bond and no victim contact.
Judge, as you heard, Mr. Remming has no prior contact with the criminal justice system. Unfortunately, at this time, he is not working. He's 30 years old. He advised me his mother will help pay for his bond. She works at a laundromat. We're going to be requesting a $3,500 bond on Mr. Remming's behalf, Judge.
All right, $7,500 bond, no victim contact. No victim contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes.
Okay. All right. Villalobos, Saul Becerra Villalobos.
He's here, present, Judge, and May.
All right, Mr. Villalobos is before the court on one charge of aggravated assault with a deadly weapon, domestic, number 2, touch or strike battery. And I find probable cause.
Your Honor, the only previous arrest I see is a 2002 aggravated assault with a deadly weapon that was dropped. Your Honor, I'm going to be requesting a $50,000 bond on count 1, a $5,000 bond on count 2. Pretrial release of the GPS monitor, level 1. No contact with the victim or, one moment. With the victim and both of her children that are listed in the report. I have great concern for the victim's safety, the safety of her children, based on the threats that Mr. Becerra made, that he was brazen enough, according to the report, to threaten the victim with violence while police were right outside, essentially threatening her what would happen to her and her family if she didn't get the police out of there. Making threats to a child, what would happen to the child's family if police became involved. And now that the police have gotten involved, my fear and concern for this family is just greater.
Okay.
Judge, fortunately, Mr. Becerra advised me he has no one to call to help post any sort of monetary bond. As you heard, he has a clean record. He's self-employed. He lays tile for a living. He makes approximately $800 a week. He's been living here in our community for 20-plus years. He's 37. He will be finding a separate place where to reside and be abiding by the court order as far as no contact. But unfortunately, like I said, he has no one to call to help post his monetary bond.
All right, so no victim contact, start there, and no victim contact means no phone calls, no text messages, no social media, no third-party contact. I am specifically ordering a 500 feet stay away. Do you understand that, sir?
Yes, sir.
All right. All right. These allegations are concerning. We have a young child who is afraid and had to wait until she got to school to tell them what was going on in the home. And then, as was stated before, that at the first time the law enforcement was called, was that there was threats while law enforcement was at the door. And so I am going to, impose a $75,000 bond on charge number 1. And on number 2, I'm going to impose a $10,000 bond. If Mr. Becerra Villalobos posts his bond, He will be on a level 1 pretrial supervision. I'm ordering no weapons or firearms. And no contact with the victim means all the persons, the victims and/or witnesses that are listed in the affidavit. Okay.
Judge,
Yes.
one request. My understanding, Mr. Riccara has all his personal belongings there. Can you go one time with law enforcement and company
Nope.
to retrieve his property?
No, I'm denying that request. 75 and 10. All right, Louis Hodge.
He's approaching, Judge. He has private counsel, Mr. Anthony Quinn.
Mr. Hodge, when did you hire Mr. Quinn?
He's a long time attorney, but I hired him on November 21st.
You hired him for this arrest?
He doesn't know about it, I guess. I just found out last night.
Oh, it's an ad charge.
Your Honor,
It's ad charge.
Okay.
except for one moment,
What was that?
I'm just checking. Yeah, he is the attorney of record. He's Mr. Hodge is actually scheduled for arraignment tomorrow morning before Judge McCarthy.
Okay.
So go from the 23rd to tomorrow morning?
All right, Mr. Hodge, yes.
He's also got a no bond hold on a VOP.
All right, so Mr. Hodge, I know that your attorney's not here. This is a trespassing charge with a $100 bond, and I'm also told that you have court tomorrow before your division judge.
Yes, ma'am.
What do you want to do?
I'll wait for court tomorrow.
All right, so I'll find probable cause for the ad charge at this time and just leave the bond at $100, okay? All right, Mr. Bogenschutz, you got your paperwork? I do, Your Honor. All right, if you'll give me just a few moments so I can review it, and then I'll address your case. All right, it's just, All right, we can address Matthew Bro on page 15 at this time. All right, Mr. Bro is facing one charge of false report of bomb, explosive weapon, or mass destruction. I find probable cause for that charge. And I'll hear from the parties.
Your Honor, as far as Mr. Bro's criminal history, there's a 2018 resisting without violence. That isn't of great concern. The allegations in the warrant and affidavit are of great concern. I'm going to be requesting a $50,000 bond, pretrial release with a GPS monitor, no return to the this place of business, this incident location. One moment. Yes, Precision Metal Industries, Your Honor. No contact with any employees of that business. I am going to be requesting a GPS monitor, no possession of any firearms, weapons, ammunition. It is mentioned in the affidavit that Mr. Bro does possess a concealed weapons permit. I would ask for an order that that permit be surrendered prior to his release from custody.
Mr. Bogenschutz?
Thank you, Judge. Judge, I had briefly, about as briefly, I think, as the court had the opportunity to take a look through this, and I think in parsing it down to what the allegation appears to be is that even though the statute is a pretty far-ranging statute, it's a firearm. That's what we're talking about, not a weapon of mass destruction or a bomb or anything like that. That doesn't mean that I don't consider it serious. Because although at the end of the day, I think what's going to happen in this case, if you look at this closely, it's going to be one time he's in the office being kidded by other employees and makes the comment on this one day, December 9th, and then suddenly on December the 15th, he's called by the officer. He then drives over here from Tampa on the telephone call that the officer wants to talk to him, comes into my office, we call the officer tells us, Detective Meltzer tells us, there's actually a warrant for his arrest. We immediately walk him over to the county jail without incident and surrender him. So this is a defendant who has come over here on his own from Tampa on a telephone call that he really didn't have any idea what was happening with, and nevertheless was present, surrendered himself, and now is in court before you. But as I said, and as I started to say, I think at the end of the day, this is going to be that this incident was the one that was not really serious, but certainly should be taken seriously, especially by an outsider who doesn't know the inside politics of that office. Having said that, I would suggest to the court this defendant is 23 years old. He's lived here most of his life, if not all of his life, 264 months according to the lead sheet in this. He is trying to, the reason he was in Tampa, he's trying to move over there. He has many thousands of dollars worth of welding equipment, which is what he does. At Precision, the defendant's father, with whom he lives, is making arrangements himself to go over and get that equipment. Obviously, we're not the defendant be permitted to do that even with a police officer. We agree that there should be no contact. We agree that that this is a bondable offense. It's a second-degree felony. I'm suggesting respectfully, Judge, that with his background, which is one, and I think the resisting was a withheld, the one misdemeanor charge that he's had in his life should not unduly restrict him in what kind of bond this court may set. He is living with his father. He's lived there for 5 years. His mother and father are divorced. His mother lives in Pompano. The father lives in Pompano as well. The mother has already talked to a bondsman. The bondsman is satisfied with collateral, so depending on what the bond is, so that we're in a position where he can bond out if the bond is reasonable. And under these circumstances, we request that a bond be the standard bond for a second-degree felony, which is $2,500 with special conditions. I would ask the court not to put him on an EMS, or at least permit him to transfer over to Tampa, because that's where he intends to live, and that's where he was when this incident was advised by the police officer he needed to speak about.
Your Honor, if I could briefly respond. First, I would just want to note, and it is mentioned in the warrant, the charge This statute was amended, I believe, a couple years ago to also include the threatened use of a firearm. Your Honor, as far as whether it was a joke or not, I don't know. I don't have insight into Mr. Brown's mind. What I do know is in the environment we all find ourselves in, it is common knowledge, this is not a joking matter, that these type of threats are taken seriously and have to be taken seriously. And I think every reasonable person in our community realizes that. Your Honor, I do believe the GPS monitor is appropriate based on these allegations. I think it is reasonable and necessary for the foreseeable future until further order of the court to know where Mr. Bro is at all times. I'm sorry, the only other thing I would note, as far as any claims Mr. Bro may have, let's remember, just days prior to this incident, he discharged a firearm, whether it was intentionally or accidental, lied about it to the police and openly admitted it to his coworkers, that not only did he discharge the firearm, but that he just told law enforcement that no, he did not.
I certainly agree that this is a serious matter and has to be taken seriously, especially in this post-Parkland world that we live in. But I think that the seriousness of it is indicated by the fact that it's a statutory second-degree felony now, and it's been changed for that reason. So now he's under the aegis of the court. Now he's not out talking to police officers, talking to his friends. He's away from that situation, and the court now has jurisdiction over him. So I think the court can exercise that jurisdiction in ways other than to put him on an EMS and put him on a $50,000 bond that, frankly, and I can't say this with any particularity, but frankly may be very difficult for him to make. He's a welder. He's 23 years old, and he's depending on his parents to help him with bond.
Right, so I think we all agree that we have to take these allegations seriously. We unfortunately do live in that time, in this time when you don't make jokes about whatever, even if it was a joke. There are allegations that it's so much that other employees had concerns, and so there's cause for concern. And so we have to take it for what it is at this point. I don't know what's going to come out later on in investigating this matter, but as of this point with probable cause, I do find probable cause. I am going to impose a $20,000 bond on charge number, on the case. I am going to order no victim contact, and Mr. Bro, that means no phone calls, no text messages, no social media, no third-party contact. You cannot have any contact with the employees at this place of employment, PMI. And no weapons or any firearms. You cannot possess any weapons, firearms, or ammunition. Do you understand that? If you have any, you need to surrender them before, upon release to
I've
law
had that
enforcement.
discussion with him, Judge.
You have that? Okay.
Yes, ma'am.
All right.
And we will surrender the carry permit.
And surrender the carrying the concealed weapons permit.
Your Honor, so I know how to write the order. Is the court allowing that to be done after release?
What?
The
Has the
surrender of
firearm
permit.
already been surrendered, Mr. Bogenschutz?
Your Honor, the firearm has not, to my knowledge, it certainly hasn't been in my office, and we just got into this yesterday at about probably 2 o'clock, right before he surrendered. I know that his father still resides in the residence. I'll have his father bring the permit.
So surrender
To my
prior
office.
to release, okay?
Is that firearms and
And the
permit?
firearms.
Okay.
Right,
Yeah,
Yes.
okay.
We will take custody of them, Judge, and not permit anybody to have them until such time as the case is resolved, assuming he's qualified to have a firearm after the case is resolved.
Okay. So he was in Tampa when he returned when?
He got a telephone call on Sunday, drove back here in the evening immediately, and came into our office yesterday in the late morning. We called Officer Mentzer. He said that there was a warrant out for his arrest. We took him over right then. So on a telephone call, he came back from Tampa.
Okay.
And made sure he was here to talk to an officer. And when we found out the officer had originally asked him to come in for an interview, we called, and the officer said, look, we have a warrant for his arrest, and my associate took him over and surrendered him.
All right. All right, so I'll leave those conditions in place, okay?
Yes,
Yeah,
ma'am.
and I just don't want to see any issues once the conditions are satisfied. Mr. Bogenschutz, are you going to be surrendering the firearm and the permit to local law enforcement? The reason being is,
I normally keep them.
yeah, but my only concern about that is if the issue is the order that it must be done prior to release, then some type of receipt is going to have to be provided
It's fine.
Yeah, surrender to law
to the
enforcement.
jail, so law enforcement would be able to provide you with that as long as you have a copy of the order.
Judge, I've had problems with law enforcement surrendering firearms in the past. I'm right now a year into trying to get one gun back on a case that Coconut Creek has been playing with, and I have a sneaking suspicion that it's in some law enforcement's car. So it's difficult sometimes to get those returned. So I'm asking that the court permit us to take them. We have done it on several occasions. We've actually stored the firearms in our office. This case will be different because we also have a concealed weapons permit that we have to get. I think his father has the ability to take the firearms to our office. If the court wants us to, and if it's part of the order, if the court wants us to surrender to law enforcement, obviously we'll do that.
I'll prefer it to be surrendered to law enforcement. Okay,
Okay.
so let's just put that in
That's
the
fine.
order.
That's fine.
Okay? All right, thank you.
Thank you, Your Honor.
Judge, if I can just quickly go back to page 1, Miss Polly. She was at North Broward. She needed a Bangladesh interpreter. I've been able to secure one this afternoon at 1 o'clock, so I told
Right.
the deputy to go ahead and take her back, and we would hear it at 1.
All right, so we'll reset at 1,
Perfect.
okay?
Great. Thank you, Judge.
All right. Somebody had signed in on her, so. Okay, all right, so we'll reset Polly for 1 PM, okay? Alexander Zydor,
Good question, Judge.
Your Honor,
yes,
before we go too far down the road, I've just been advised on Polly, was the interpreter,
for
like, you
this
weren't requesting an
afternoon.
interpreter for the defendant, were you?
Oh, yeah.
Oh, for the defendant?
Yeah.
Then, no.
All right, so Alexander Zydor is before the court on 1 charge of resisting officer without violence. Number 2, trespassing occupied structure or conveyance. I find probable cause. I'll hear from the parties on Mr. Zydor.
Judge, my understanding is being Mr. Sidor, this is first contact with the criminal justice system. He's been here his whole entire life. He's 18 years old. He's a graduate of Piper High School, class of 2019. His GPA when he graduated is 2.8. He intends on enrolling in Broward College this coming January. Oh, you're already enrolled?
Yeah, I'm already enrolled. It started January.
He's already enrolled, and my understanding is he already filled out the financial aid package. But considering Judge he has no prior record, I'm asking at this time if the court would consider releasing him ROR.
I have no objection, Judge. He has no history.
I'm gonna release Mrs. Zydor to standard pretrial supervision. Your attorney can give you the information for the pretrial office, and you need to report by tomorrow morning. If you don't report, a warrant will be issued for your arrest. And no return to that location, sir. No return to that location. Do you understand that?
Yeah.
Okay. Gablin Filsami.
He's a medical research on it.
Mr. Filsami is a medical reset. Frederick Brown. Where's Frederick Brown? Conti? Conti, do we have Frederick Brown?
Yes, ma'am.
All right. All right, Mr. Brown, you're before the court. This is for an additional charge. Number 2, possession of alprazolam.
Yes.
I find probable cause, sir, and you have a $1,000 bond on that charge, okay?
Okay.
All right.
Yes.
Creighton McMorris.
He's approaching, Judge. He's here at me. And Judge, whenever the court's ready, we're ready to proceed on Miss Beverly Lauriston.
Okay, Mr. McMorris is before the court. 1 charge of driving while license suspended. Number 2 is a parole violation, and that is a no bond hold for Department of Corrections. You'll have to appear before the parole board on that charge. I find probable cause, and you have a $100 bond on charge number 1, okay? And then we can go back to Beverly Lauriston.
She's approaching, Judge.
Ms. Lauriston is before the court on 1 charge of abuse of child without great bodily harm. I find probable cause.
Judge, my understanding is Miss Lauriston has no prior contact with the criminal justice system. She's been residing in the same location for a year now. It's an apartment in Pompano Beach. My understanding is the total rent is $1,050. She's been living in our community for the past 6 years. She's 24 years old. She is employed. She works at a bakery where she's been employed there for 3 years, and she makes approximately $500 a week. Judge, she does have family members that live in our community. She's going to be reaching out to them to help post her monetary bond. But considering, Judge, this is her first arrest, we're going to be asking for a $2,000 bond on her behalf, Judge.
Your Honor, and while I see no adult history, I am going to be requesting a $7,500 bond. I believe the allegations in this case are aggravating, noting I think it's extremely fortunate that the victim was not injured, noting the age of the child and the alleged act of abuse towards the child.
All right, I'm going to impose a $5,000 bond and no victim contact. Leondrick Osborne. Yeah, there's only
He's approaching,
1
Judge.
burglary, 2 attempted burglaries, and
Correct,
then
Judge.
there's not a 4th, right? That's, okay. All right, thank you. All right, so, Mr. Osborne,
Your Honor, if I may?
yes.
The 4th count, the structure, it was a secure parking lot for the Fort Lauderdale, City of Fort Lauderdale government building. I believe the allegation is he did not have any legitimate purpose or reason, or he unlawfully entered the secure parking lot to commit the car burglaries.
Right, but you agree that the other 2 should be
Oh,
attempted?
absolutely. And the officer puts that in his.
Okay. All right, so Mr. Osborne is before the court. Charge one is burglary, unoccupied conveyance unarmed. And then 2 and 3 will be attempted burglary, unoccupied conveyance unarmed. Number 4, burglary of an unoccupied structure unarmed. All right? So if I find probable cause for those charges.
Judge, my understanding, Mr. Osborne has a clean record. This is the first time he's been arrested in his life. He is a registered voter here in Broward County. He's 20 years old, been here his whole entire life. At this time, what he advised me he's doing, he's currently in the process of signing up in order to obtain his GED. He is currently looking for work. He lives with his mother. His mother does not work. She is on disability. They live here locally in Fort Lauderdale where they rent, they do not own. And he believes the monthly rent is approximately $900 a month. Judge, his financial resources are limited. He did advise me, I did explain to him, he'll probably be getting a letter in the mail in about 30 days telling him when to come back to court. He will be coming back to court. But Judge, we're going to be asking, considering if the state can verify he has a clean record, we're going to be asking on the third-degree felonies, a $1,000 bond on count 1, $500 bond on counts 2 and 3, and also a $500 bond on count 4. So we're requesting a total of $2,500 on Mr. Osborne's behalf.
Your Honor, the only thing I see is a juvenile. He had a grand theft auto a few years ago. He did complete a diversion program successfully.
All right, so I'll grant the request $1,000 on charge 1, and then 500 on the other remaining 3 charges. No return to this location. Okay. All right. Richard Pierre Philippe.
Mr. Pierre Philippe, come on, please. Mr. Person, Judge.
All right, Mr. Pierre Philippe is before the court on 1 charge of possession with intent to sell, manufacture, or deliver cocaine. Number 2, possession of alprazolam. 3 and 4 are traffic infractions that are not for magistrate. I find probable cause.
Judge, at this time, nothing to request by the defense.
All right, so I'll leave the standard bonds in place.
I'll call it now.
Sissos Morel.
Morel, come on up, please.
All right, Mr. Morel is before the court. Charge 1 is failure to register motor vehicle. Number 2, possession of blank or fictitious unlawfully issued driver's license. Number 3, driving while license suspended. Number 4, fraud, misrepresenting self to commit personal ID. Number 5, false ID given to law enforcement. And number 6 is a civil writ with a purge amount of $1,057. That's for the Department of Revenue. All right, I find probable cause.
Judge, my understanding, this is Mr. Morel's first arrest. He's for 13 years. He's 28 years old. He lives in Miami Gardens with his girlfriend and 1-year-old daughter. My understanding is his girlfriend is also pregnant. She's about 10 weeks pregnant. She does not work. Mr. Morel is the sole financial provider of his household. They rent at an efficiency where they pay approximately $600 per month. Judge, Mr. Morel does various side works, but his financial resources are such that he's not going to be able to afford the standard bonds which are currently in place. I was going to ask the court to consider releasing Mr. Morel under supervision so that he can reach out to all his family members to help pay for count 6, the purge amount on count 6. So that's why I'm asking the court to consider releasing him on pretrial release.
I would just advise the court, Mr. Morel has a $2,500 bond on a warrant out of Dade County from 2017, failure to appear in a DWLS.
All right, based on the allegations, what it took for the officers to get to the true identity of Mr. Morel, I am going to leave the bonds in place at this time, okay? Luis Centeno,
Mr. Sentinel, come on up, please.
Mr. Centeno is before the court on one charge of grand theft auto. It was from a not in custody capias that was issued. I find probable cause.
Judge, nothing to request at this time.
All right, Mr. Centeno is $1,000 bond. Shane Morris,
Mr. Morris, come on up, please.
all right, Mr. Morris is before the court on one charge. Charge one is trafficking in fentanyl, more than 4 grams, less than 14 grams. And number two is possession of drug paraphernalia. I find probable cause.
Judge, Mr. Morris is not going to be able to afford the standard bond, which is currently in place, $75,000. Right now, he does work. He's a Lyft driver. He's been doing that for the past 6 months, making about $500 a week. He's 32 years old. He's been here his whole life. He's a registered voter in our community. From what he advises me, he really doesn't have any sort of financial resources. He lives in Davie with his mother and his 2 children. He's hoping his family will be able to afford to post his bond. So we're going to be requesting a $10,000 bond on Mr. Morris's behalf on count 1. And my understanding, Judge, he does have prior contact with the criminal justice system, but I believe it's dated as approximately 10 years ago.
All right, I'll grant the $10,000 bond on 1, and he has a $100 bond on 2. Van Darrell Doe,
Mr. Doe, come on up, please.
all right, Mr. Doe, you're before the court today because you have, 1, a misdemeanor capias. That capias was issued for not showing up for a status hearing on October 21st, where the charge is operating without a valid driver's license. And then number 2 is a felony capias that was issued by Judge Scher because you did not show for a status hearing on where the charge is grand theft auto, and she signed a capias with a no bond hold. So I find probable cause. You have court tomorrow with Judge Scher, and then on the misdemeanor matter, you have court the following day. Okay?
Gotcha.
Jermond Radcliffe,
Mr. Radcliffe, Judge, is approaching. I asked him, and my colleague also asked him, he's declining the services of public defender.
all right? Mr. Radcliffe, do you understand that you are entitled to an attorney for this hearing today?
Yes.
And are you hiring private counsel?
Yes, I gotta make a couple of phone calls and
Okay.
I'm working on it.
And so for this morning's purposes, are you representing yourself?
Yes.
All right? You are before the court today, sir. Charge 1, burglary, occupied conveyance, unarmed. Number 2, grand theft auto. Number 3, passing forged or falsely embossed or altered credit card. Number 4, possession of counterfeit driver's license or ID. Number 5, resisting officer without violence. I find probable cause for these charges. Sir, I'll hear from the state, whatever they have to tell me, and then you have no counsel, so I need to remind you that everything you say can and will be used against you at a later time. Everything is being recorded. If you wish to say anything about setting your bond, I'll certainly hear from you after I've heard from the state, okay?
From what state?
from
So I don't,
what?
so I don't have a bond now?
Oh, I am going to make a determination. There is some charges that don't have a bond, that bonds have to be set.
Okay.
Yes.
Your Honor, I have a concern about with Mr. Radcliffe's ties to the community. The booking sheet has an at-large address. The probable cause affidavit shows an Illinois address. This occurred at the airport. It does appear Mr. Radcliffe is transient to some degree. I'm showing recent arrests in Iowa, Texas, and Kentucky. In Iowa, he had a forgery from 2016. Texas, unauthorized use of a vehicle, evading arrest from November. It looks like that's still pending. That was from November 13th of this year,
In what state?
Texas. And in Kentucky, this also appears to be pending from a September 13th, 2018 arrest, criminal possession of a forged instrument, 2 counts, fraudulent use of a credit card.
All right, sir, this is your turn. Do you wish to say anything?
No, I just wanted to know, like, when I would be able to, when would I know about a bond?
Well, that's what we're doing right now.
Okay.
All right. Well, so based on the allegations that I have before me, which are that you fraudulently obtained a rental vehicle using a fake credit card and driver's license, and hearing that you have other pending charges in other states that also involves fraud, I find probable cause. I am going to impose a $10,000 bond on charge number 1. And then on 2, 3, and 4, you have a $1,000 bond, and number 5, you have a $100 bond. Okay? All right. Paul Carter.
Mr. Carter, come on up, please. Please approach the judge.
Mr. Carter is before the court on one charge of battery on a person 65 years of age or older, and I find probable cause.
Your Honor, I'm going to be requesting a $15,000 bond and a GPS monitor, no victim contact. I'm concerned about the level of violence that was allegedly committed against the 85-year-old victim, who also happens to be blind. He obviously has a limited ability to protect himself should Mr. Carter decide to attack him again. That's why I'm requesting the GPS monitor to ensure, or at least provide pretrial release to allow the state to know that he is staying away from this residence, because it does appear they reside together. Mr. Carter is a career offender in the state of Florida. He's actually been qualified as a habitual violent offender. That stems from a 1990 strong-arm robbery, where he was sentenced to 20 years in state prison. That was preceded by a 1987 attempted robbery with a firearm or deadly weapon and aggravated battery, where he was sentenced to 4 years in state prison. And 2006, he had a possession of cocaine.
Okay?
Judge, Mr. Carter's not working at this time. He's looking for employment. He's been here his whole entire life. I do understand, and I was advised by Mr. Carter that he does have a record, but from what he advised me, he believes he's been clean for about 3 years now. I did advise him as far as the no contact order. He'll be finding a separate place where to reside. He's asking if the court would sign an order allowing him to go one time with law enforcement and retrieve his personal belongings. But from what he advised me, Judge, there's no one that he's going to be able to contact to help post his monetary bond. So he's asking if the court would consider releasing him under supervision.
I am going to deny that. I'm going to impose a $10,000 bond. No victim contact. I will sign the order for one time to go to the location with law enforcement to pick up his items. Sir, no victim contact means no phone calls, no text messaging, no social media, No third-party contact. Do you understand that, sir?
Yes, Your Honor.
Okay. All right. And then Joseph Mash. Mr. Mash still on medical loan?
That's why I passed it along.
Yes?
Yes, Judge.
All right, so Mr. Mash is on medical loan. All right, is there anything else that we had to go back to?
I don't believe so.
Yes, with law enforcement. Yes. All right, we are at the end of our docket, and good morning to the students from Renaissance Charter Middle School. Good morning. All right. We're gonna go off the record. Thank you, everyone. I'll see you at 1.